My name's Annie Showalter. I'm the editor-in-chief of the Duke Journal of Comparative and International Law. And today it's my pleasure to introduce our symposium's keynote speaker, Dr. Escobar. Since 2012, Dr. Escobar has been the ILC's Special Rapporteur on the immunity of state officials from foreign criminal jurisdiction. She's also serving as the Director of Public International Law at the National University of Distance Education in Madrid. And before that, she was Chief Legal Advisor for Spanish Foreign Affairs and also a judge on the Permanent Court of Arbitration. So it's truly our pleasure to hear a little bit from her today about a subject that she's so expert in. If you could all join me in welcoming her.
Thank you very much. As my English is not so good, I will read my statement because I think that it's better not to forget anything that I intend to transmit to you. First of all, I thank you very much for the introduction, and I would like to congratulate the Duke Comparative and International Law Journal for organizing this interesting symposium. And at the same time, I would like to express as well how much I appreciate your invitation to attend to it and to let me give a brief presentation and to make some comments on the work of the International Law Commission on the immunity of state officials from foreign criminal jurisdiction, a topic that, as all of you know, is both legally important and politically sensitive. As you know, the ILC included the topic immunity of state officials from foreign criminal jurisdiction in its long-term program in 2006 and decided to appoint a special rapporteur in 2007. The United Nations Secretariat elaborated an interesting memorandum on the topic in 2008, and the first special rapporteur, the Ambassador Kolotkin, submitted 3 reports in 2008, 2010, and 2011. The Commission and the Subcommittee of the General Assembly considered those reports in 2008 and 2011. At that moment, the ILC only had just one formal debate in the plenary, and this debate on the topic was inconclusive and circular. In fact, no consensus was identified with regard to most of the elements contained in the report submitted by Special Rapporteur Kolotkin. At the moment of my appointment as a Special Rapporteur in 2012, my main concern was to provide the Commission with an instrument to address the topic in a structured and productive way. This was the purpose of my first report, submitted in May 2012, few days after my appointment. This report was of preliminary nature in 2 different senses. First, it was preliminary because its purpose was to describe the état de lieu on the topic, and second, it was preliminary as well because the report included some proposals about a new methodology suggested to address the topic during the current quinquennium. But at the same time, the report had a preliminary nature from the perspective of the identification of several substantive elements the Commission needed to take into account when to address the topic during the quinquennium, keeping in mind the previous work but introducing new elements and aspects that members of the Commission had pointed out during the previous consideration of the topic. The ILC, in general terms, agreed on the proposals included in my preliminary report, which so that constitute the starting point for the Commission's work during the present quinquennium. According to these proposals, my report has been successively devoted to the following aspect of the topic. The scope of the topic, 2013, normative elements of the immunity ratione persone, 2013, normative elements of the immunity ratione materie, 2004 and 2015. In addition, I plan to submit 2 more reports, limitation and exceptions to immunity, next year, and the procedural elements and rules related to the immunity of state officials 2017, of course, if I am re-elected as an ILC member by the General Assembly next year, because next year we have the election for the Commission. Regarding this program of work, I'm aware that some issues must be taken into account in relation with two or more parts of the global study. And I am also aware of the risk to have a limited approach to these elements when they are analyzed in different reports. The isolated analysis, for example, of the concept of officials or act performed in an official capacity, or the approach to exceptions and limitations show us what is this risk. But I consider that the method based on a step-by-step approach is the most useful way to have unstructured work to facilitate an organized debate in the Commission and in the SID Committee, and to facilitate a practical and feasible outcome for the Commission's work. In spite of some doubt expressed by certain members of the Commission, the ILC at the end has agreed upon this program of work. Due to the limited time for my speech, I would like to sum up in a concise manner the work of the ILC until today. In addition, I would like to comment on some aspect of the topic that I consider to be most relevant for the attendees at this symposium. In particular, the issue of exceptions and limitations, and, on the other hand, the relationship between immunities from international courts and from domestic courts. Let me start with some comments related to the scope of the topic. Draft Article 1, adopted by the ILC in 2013, refers to the scope of the topic. I would like to call your attention in particular on two aspects. First, the decision of not including the immunities from civil jurisdiction and the immunities from international criminal jurisdiction within the scope of the topic. And second, the inclusion of a non-prejudice clause related to other forms of immunities from criminal jurisdiction recognized under international law and qualified as special regimes. I'm referring, of course, to the diplomatic and consular immunities, immunities related with international organizations, and immunities enjoyed by military forces of a state. The Commission purpose is to adopt a draft articles containing the general legal regime of immunity of a state official from foreign criminal jurisdiction, letting aside the existing special regimes and the regime applicable to immunity from international criminal tribunals. However, I would like to draw your attention as well to the open debate among the members of the ILC about whether the Commission must take into account in this work the existence of rules of international law on immunity that are applicable before international courts and tribunals. This issue has been raised by several states at the SID Committee, and I will come back on this issue in the second part of my speech. With regard to the distinction between immunity ratione personae and immunity ratione materiae, which is one of the core elements of the current work at the Commission, I have to say that, as I propose in my preliminary report and in my second report, the Commission has agreed on instituting a distinction between immunity ratione personae and immunity ratione materiae. This distinction, well established in the legal literature, was included in the reports by the former Special Rapporteur Kolotkin, but only with a descriptive purpose. In a different vein, the Commission, in its 2013 session, has considered these two types of immunities from a normative perspective, taking into account that each type has different normative elements and, at least in some aspect, could be governed by different rules. This agreement opens the possibility to establish two different legal regimes, each of them applicable to one type of immunity from criminal jurisdiction. Although Although the Commission has decided not to define for the moment the two types of immunity, it has been accepted, however, as a general understanding, the existence of three elements that must be considered in order to distinguish the immunity ratione personae and immunity ratione materiae. Those elements are the classic ones. First, immunity ratione personae applies only to several state officials of high rank level, the so-called troika, and immunity ratione materiae could apply to a broad range of state officials. Second, immunity ratione personae covers both private and official acts, and immunity ratione personae covers only acts performed in an official capacity. And third, immunity ratione personae applies only during the term of office of state officials, and immunity ratione materiae has no temporal limit. This distinction between immunity ratione personae and immunity ratione materiae presents, however, some gray zones, which have been the object of an interesting debate on the Commission during the last session in July 2015. If you are interested, I draw your attention. You can go to the summary records for the last session. I think that is very interesting to read it. With regard to the immunity ratione personae, in 2013, the Commission adopted two draft articles containing the normative elements of immunity ratione personae. Draft Article 1, which refers to the subjective dimension of immunity, limits the scope of this type of immunity to the persons exercising one of the posts or functions pertaining to the so-called troika, head of state, head of government, and Minister for Foreign Affairs. Although some members of the ILC expressed different points of view with regard to this matter in order to extend or to reduce the number of state officials enjoying immunity ratione personae, finally, a general consensus was reached in favor of a restrictive approach. Moreover, the Commission expressed its view in favor of the applicability of the rules of immunity for special missions to high officials other than the Troika members. With regard to the substantive scope of the immunity ratione personae, the Commission has maintained a traditional approach, attributing immunity to all acts of head of state, heads of government, and Minister for Foreign Affairs during the period of exercise of their mandates, whether there are private acts or acts performed in an official capacity. This conclusion does not imply that any decision has been taken on the exercise of exceptions to immunity ratione personae, which was a matter of strong debate at the Commission to be addressed in my fifth report, and which I will refer later. With regard to the temporal scope of immunity, I must underline the Commission's agreement on considering that immunity ratione personae ends on the date when the mandate of the official finishes. This immunity cannot be extended after this date, nor even for act performed in an official capacity, which will no longer be covered by immunity ratione personae. However, the issue of the nature of the remaining immunity covering such official acts has been raised again during the last session on the occasion of the adoption by the drafting committee of draft Article 6.3 devoted to the immunity ratione materia. In 2014 and 2015 sessions, the ILC has addressed the normative elements of the immunity ratione materia, in particular the concept of state official and the concept of act performed in an official capacity. In addition, the temporal elements of these kinds of immunity has been considered. The definition of state officials adopted by the ILC reads as follows. State officials means any individual who represents the state or who exercises state functions. By this definition, the ILC decided to offer a simple and comprehensive concept of state officials, covering both the individuals enjoying immunity ratione persone and immunity ratione materia. On the other hand, the phrase who represent the state or who exercise state functions express the need for a link, a close link between the state and its official as a sine qua non requirement to enjoy immunity. In this regard, attention must be drawn to the fact that a state official may fulfill both requirements or only one of them. In any case, whether an state official is representing the state or not, or is exercising state functions or not, must be determined on a case-by-case basis. Even though the definition of a state official is a general one, this definition has a specific significance for immunity ratione materia. In this regard, the ILC has considered that it cannot use the technique of identification eu nomine of these officials, in particular because of the diversity of the position of the individuals to whom immunity may apply, and on the variety of national legal systems that determine which persons are their official. However, the Commission has included in the commentary to draft Article 2E, by way of examples, a list of persons having appeared in national and international case law regarding immunity, regarding immunity from jurisdiction. In any case, the immunity ratione materia could cover the former members of the Troika whose term of office has come to an end with respect to acts performed in an official capacity during such term of office. You can find that in draft Article 6.3. At any rate, attention must be drawn on the fact that a state official only enjoys immunity ratione materia when he is acting as such. This requirement excludes the possibility to allege the immunity ratione materia when a state official acts as a private person, even if it acts in the color of an official, an state official. The second normative element of the immunity ratione materia is the concept of act performed in an official capacity, which has been addressed by the ILC at 2015 session. The drafting committee has adopted the following definition, and I quote, "An act performed in an official capacity means any act performed by a state official in the exercise of state authority." End of quote. This definition must be considered by the revision by the Commission as a whole in 2016, together with the commentary to be submitted at this moment to the Commission. At any rate, it is possible to underline now some provisional and preliminary comments on this definition. First, the ILC has decided to adopt a definition as simple as possible, almost apparently. I think that is not as simple as possible. Second, the reference to a state authority instituted the link between the act and the exercise of public or sovereignty powers. However, the ILC has decided not to use the word sovereignty, taking into account the views expressed by several members of the Commission about the difficulty to define this concept, and they had decided not to use the wording governmental authority that appears in a lot of legal documents prepared by the International Law Commission, because several members consider that this phrase could be so restrictive and excluding the possibility of application to the state official pertaining to the judicial power, legislative, etc. Nevertheless, the ILC has considered the kind of act that has been considered as performed in an official capacity by international and domestic court, and we have had an interesting debate on the examples I have included in my fourth report that show that in most of the cases, the immunity relazione materia is alleged only with respect to the core elements of the sovereignty authority in a strict sense. And third, whether the state authority exists or not must be analyzed case by case. And lastly, the ILC has defined the the immunity razione materia as a permanent one, establishing in draft Article 6, paragraph 2, that this immunity, and I quote, continue to subsist after the individuals concerned have ceased to be state officials, end of quote. Now I would like to make some comments about limits and exceptions. The limits and exceptions to immunity constitute, without any doubt, one of the most controversial elements of the topic. This controversial nature has been expressed both by the ILC members during the debate within the Commission and by states in their statements before the CID Committee. However, former Special Rapporteur Kolotkin considered in general that it was not possible under contemporary international law to identify any exceptions to immunity from criminal jurisdiction of state officials. The opinion of the ILC members is divided, and some members of the Commission have expressed their strong opposition to such a general conclusion. In fact, the issue of exceptions to immunity has been present since the very beginning of the current quinquennium in the works of the International Law Commission. A similar division of opinions is also present in the statements produced by states at the CID Committee. The different response to this issue focus in particular on the existence of an exception with regard to international crimes. That is the core of the debate. In favor of the inapplicability of exceptions, the main argument has been that the act of an official which can be in favor of the inapplicability of exception, the main argument has been that any act of an official must be able to be attributed to a state, and that for this reason, this kind of act is in itself an act of a state. And the direct beneficiary, who benefit directly from immunity is the state. A specific reading of certain judgment for the International Court of Justice has been alleged as a basis for this assessment. I am thinking, for example, the Aaron Warren case, the certain question concerning mutual judicial assistance case, and the immunity case, even if they are placed at different levels. In addition, against the applicability of exceptions, it has been argued that immunities before domestic jurisdiction and immunities before the International Court and tribunals must be dealt with separately, and that the institution of exceptions to immunity would operate only with regard to international court and tribunals. On the opposite side, those in favor of the applicability of exceptions to immunities allege the difference between state immunity and the immunity of a state official, and the existence of a trend in contemporary international law to recognize the international crime responsibility of individuals or liability of individuals for certain crimes which cannot be covered by immunity before the international criminal courts, neither before national courts. In any case, The limitations and exceptions to immunities constitute one of the core issues of the topic, and I will address this issue in my 5th report. But I can advance from my point of view in order to properly, some ideas from my point of view in order to properly address the issues related to limitation and exceptions. In this regard, I think that it is necessary to take into account the following elements. First, the emergence in contemporary international law of rules of principles that distinguish between individual responsibility and state responsibility, even if both kinds of responsibility arise as a result of the same acts. The model one act, two responsibility, and consequently the model one act, two immunities, has been included in my 4th report and has reached a big support from the ILC members and for several state members in the CID committee as well. Second, we have to take into account the progressive consolidation in international law of an agreement on the distinction between state immunity and immunity of state officials. Even if both types of immunity are construed in favor of the interests of the state, the direct beneficiaries of the immunity are different, and the exercise of the state immunity and the immunity of state officials could be governed by different rules, including with regard to the issue of exceptions. Third, we have to consider that in international law, they have been setting up several rules which attribute a specific and higher level of gravity to certain international crimes, especially war crimes, crimes against humanity, and genocide. This high level of gravity could allow us to consider the applicability of some exceptions regarding the immunity of foreign jurisdiction of state officials in a similar way as it was established in the case of international courts and tribunals. I am fully convinced that the reference to jus cogens is not the only basis for exception based in the breach of essential rules of international law. Fourth, I think that we have to take into account also the difference of subjective, temporal, and substantive scope of immunity ratione materiae and immunity ratione materiae to deal with the exceptions. In this regard, the possibility to establish two different regimes applicable to international ratione personae and international ratione materia must be discussed, and I think that remain open up to date. My last remarks will be devoted to the so-called absolute distinction between immunity from criminal foreign jurisdiction and immunity from international criminal jurisdiction. It is a distinction which writers and practitioners usually base on the different nature of both kinds of jurisdiction and on the different nature of the relationship existing between the court trying to exercise jurisdiction and the domestic courts of the state which official is or could be prosecuted. This model is, of course, an horizontal one in the case of immunity from foreign criminal jurisdiction, but is a vertical model in the case of immunity from international courts. I can agree in principle on this rationale, but I would like to make some points in order to introduce some nuance with regard to this approach that, on my own perspective, is not necessarily the majoritary approach. As I stressed in my second report, as I have said before, the scope of the draft articles exclude the the issue of immunity before international courts and tribunals. But, as I stressed in my second report, this restriction doesn't mean that the Commission must ignore the existence of international criminal tribunals nor the existence of hybrid internationalized tribunals. In fact, the need to consider the special problems presented by the hybrid criminal tribunals had been raised also by other members of the ILC. In the same way, a question has been raised regarding the effect that existing international obligations imposed on states to cooperate with international criminal tribunals would have some influence on the ILC draft articles. But due to the diversity of views expressed during the 2013 session, the Commission has decided that it was not possible for that moment to definitely address this aspect. But I think that we can find some examples in the practice that show us that it exists some kind of relation between international criminal tribunals and domestic criminal tribunals that could have some influence on the issue of immunities. If I speak in temporary order, I would like to refer, first of all, to the judgment from the Italian Constitutional Court in the case related to the possibility to implement in internal order of the International Court of Justice judgment on immunity case. I'm aware that is a matter on the side of state immunities, but almost it put on the table the idea that the relationship between domestic courts and international courts with regard to the immunities is not easy, and we have to think about how to offer some useful ideas to solve this problem. But for me, at this moment, the most important example is, without any doubt, the South African case related to the arrest warrant issued by the International Criminal Court with regard to President al-Bashir when he was in official visit in Pretoria for participating in the African Union Summit. I think that this case shows how is important and how is the extreme difficulty to establish a radical borderline between immunity from criminal foreign jurisdiction and immunity from international criminal jurisdiction. Actually, I think that these two regimes have at least a point of contact, a link, that is the international crimes. For this reason, I think that the Commission has to take into account the idea of the international crimes in the future, and the Commission have to consider the evolving situation of immunities with regard to international crimes in the current days, in the last decade, probably. In my first report, I referred to several values of international law and to several principles of international law that the Commission has to take into account in order to fulfill, to perform their mandate, that is not only to codify international law, but to contribute to the progressive development on international law. And at the same time, I advise about the idea that the Commission is a subsidiary body of the General Assembly of United Nations, and that the mandate of the International Law Commission must be consistent. And when I say that must be consistent, I'm trying to explain that the work of the ILC must be consistent with the existing rules of international law, the existing principles, legal principles of international law, legal values of international law, and must be consistent with their previous works, because otherwise the Commission itself could be producing a product that can be introduced some kind of fragmentation in international law. And even if the fragmentation is not my more loved idea, I think that the idea of consistency is very important. On this, taking into account these ideas, I think that in the future years, of course next year, but probably in 2017 as well, the Commission must to debate about must to have in mind and discuss on the need for balance between different values. One of values, legal values. When I speak on values, I always speak about legal values, not political or moral values. Yeah? One value, which, of course, the sovereignty, the equal sovereignty of states. One other value, I'm not sure that is if it is a legal value, but it's related to a legal value. That is to maintain the stabilized legal international relationship. But at the same time, the ILC has to take into account the values linked to the protection of human rights, the consolidation of the international criminal law that is evolving since the end of the 80s or the beginning of the 90s, and the fight against humanity. Because nowadays I think that when we speak on fight against humanity, there are a certain trying to say that is a political value, but I don't agree with that. I can agree with that because in contemporary international law, impunity is a legal concept. Impunity is a legal concept. It's a legal concept that is the result of the application of several instruments of international law that define what constitute the most important offenses on the basis of international law, and the fight against humanity is a legal value, is a legal purpose established by international community. Of course, I'm very aware that it's very, very difficult. I'm not sure. I hopefully that the Commission could be able to perform its full mandate, but I think that we need the help from academic side, the help from a state side, and we need to make some kind of balance to establish a formula that could be acceptable for all states, but that could be acceptable for the contemporary international law. Otherwise, if we are not able to do that, and from my point of view, it's impossible to do that, we don't introduce the idea of limitation or exceptions. with a clear delimitation, and I can agree that we can balance and establish different regimes if we don't are able to include the idea of limitation as exceptions. All the exercise of the ILC, all the work of the ILC with regard to this topic, will be, is not, probably will not be succeed. Thank you very much.
Professor Escobar has graciously agreed to take any questions. So please, we're supposed to start the next section at 1:30. I believe if we go right until 1:30, we can back it up by 5 minutes. I think it's important to create this dialogue here. So please, if there are any questions.
So, Concepcion, it's great to see you. Let me actually just provide a further additional introduction for the students. Professor Escobar and I were, she was the Spanish legal advisor when I was the U.S. legal advisor, so we spent a lot of quality time together. As you may have seen from being the International Law Commission, that consists of 34 members nominated by their countries. It's to develop and codify international law. I personally think it's extremely important to have former government legal advisors on this body, and it touches on your last point. So with due respect to my academic colleagues, it's very difficult to have law professors codifying what they think is international law or should be international law that governments will then be bound by with limited input from the governments that are actually going to be bound. So from my point of view, it's very, very important to have people with Professor Escobar's experience. And I noted your last point about the balance between input from the academic community and the governmental community. And I think the work, this particular project was something that the U.S. government supported because there is no treaty, as you heard, on immunities. And the law is all over the place. And states are getting to have more facing these issues. So I think it's a very useful project. I just want to ask two questions. Go back to some of the things you said in the beginning. One, you mentioned immunity for special missions, which was a type of immunity that we didn't mention, which is basically when foreign government officials are visiting the United States as part of an official delegation. Should they have an additional form of immunity simply because they've been sent by their government? And it sounded to me like the Commission has recognized that some or maybe all members of a foreign government sent into another country on a special mission should have immunity from criminal prosecution during the time of the special mission. So I'd actually just be interested in that because it's an additional concept. And then lastly, I was very surprised to hear, if I understood it, that although it sounds like it was rejected, that some members wanted to limit head of state immunity even further than the Troika. It's hard to go from 3 to even fewer than that. And I assume that people must have been suggesting, since they can't be saying that the head of state or head of government shouldn't be immune, that they wanted to knock out foreign ministers. So I'm interested in and it's pretty well accepted, as you know, under international law. We State Department people take care of ourselves, so we always like to have the foreign minister be immune. But I'm interested to know, were there really people arguing that foreign ministers should not be immune from criminal prosecution?
Thank you, John, for your comments. I think that the composition, to complement your comment about the composition of the ILC, even if some colleagues, some very close colleagues, has criticized a lot the composition of the ILC because there are diplomats, there are practitioners, etc., I think that they are wrong. They are wrong because I think that the composition of the ILC is a good composition. We have, we are members that came for the academic world, from the legal services, diplomats specializing in international law, practitioners, and I think that all of that we need to try to offer something to states, because at the end of the day, we work for states. We doesn't work, the ILC is not even some members of the Commission, I have to say, but I will deny always, I said. Several members of the ILC consider that we are some kind of high-level university seminar. I'm a scholar, but I think that is not the function of the Commission. With regard to the two questions, yes, special missions. The question of the special mission has been raised by several members of the ILC in the framework of the debate about the definition of the subjective scope of immunity ratione personae. There was a big consensus about the idea to capture only a restrictive approach, including a restrictive approach to the immunity ratione personae. But some members of the ILC consider at the same time that what happens about the Ministry of Defense, the Ministry of International Commerce, etc., taken into account the new ways for the international relationship. But we consider, we reach an agreement, we consider that, in fact, immunity in itself is an exception. It's an exception because the general rule is the exercise of jurisdiction by the foreign state. If the state has not the possibility to exercise jurisdiction, because the presence of one foreign element, an external element that is linked to the sovereignty, etc., etc. And for this reason, we have decided that it's better to maintain only the Troika in the list of the members covered by immunity ratione personae, but at the same time, it's true that we need to consider that sometimes the head of the army, the Minister of Defense, the culture, etc., they travel, and they can be submitted to a suite in a moment. But we have considered that there are another instrument that could be useful. That is the regime. The immunity regions for special missions, because at the end of the day, the head of state, head of government, and Minister of Foreign Affairs has some kind of representativity and powers in international relationship without any necessity to obtain a power from a state. It's international law which give this. But for the other members of the government, of the high level ranking officials, we can. It is the most important is to protect them when they are abroad. And for this reason, we agreed in the idea of the applicability of special mission rules, even if we are aware, of course, that the statute of a special mission sometimes has present some problems. With regard to the restriction, of course, yes, not too much, but almost 2 or 3. One at the very beginning, and after that, 2 more members of the ILC consider that Minister for Foreign Affairs can be placed in the same level than the head of state and the head of governments. The debate evolves on around the interpretation of the Aaron Warren case before the Minister of Foreign Affairs, as well as, and at the end we reached the agreement to include the three on the basis that one of the members of the ILC made a declaration and a statement to record that he considered that for the Minister of Foreign Affairs is only on the base of the progressive development of international law. But the majority consider that the judgment, the Aaron Warren case, or almost the practice following the judgment in the Aaron Warren case, is the expression or has provoked the appearance of a customary law or customary rule.
All right, thank you. We're going to reconvene in about 5 minutes. Let's get